Good evening. The last occasion we discussed up to Order 21, Rule 53. So we'll start with Order 21, Rule 54. From Order 21, Rule 54, it would be attachment of immovable property. Already during reading of sections, we saw that the attachment of immovable property should be done by the executing court, and that this execution petition should specifically state how the property and which of the property is to be attached. Now 54 will state that initially the court should, while passing an order of attachment, should prohibit the judgment debtor from transferring or charging the property, and any person who gets a transfer or charge after the order, the same will not bind the decree. This will be the order. This order should be sent to the judgment, communicated to the judgment debtor after settling the terms of proclamation of sale. Terms of proclamation of sale, what it is, as we have discussed, what is proclamation of sale? It is announcement of sale. Announcement of sale and its terms. The court will state the description of the property. It will state who is the owner, what is the title documents that is available with the court, when an inspection can be, the period during which an inspection can be done. Then it will fix an upset price. Upset price means the value the parties. Normally, the parties should suggest. The judgment debtor as well as the decree holder should suggest, and the court should take note of that, and only with that the upset price should be fixed. The court cannot by itself fix, or it should take the help of some expert to fix the upset price. The proclamation order for attachment, that is for sale. This is for attachment. Proclamation means announcing that an attachment has been made. Announcing that an attachment has been made will be usually by a tom-tom in the place where the attachment is made. That is the property which is attached, in the property which is attached. Then the copy of the order will be affixed in the property, in the court, in the collector office, and in the local panchayat office where the property is situated. This is how it is done. Then 55 will state how, when the decree is satisfied, the court should raise attachment. We all know that once a payment is effected to discharge the decree, it is for the court to immediately order raising of attachment without waiting for judgment debtor to file an application to raise an attachment. Because, see, the judgment debtor has suffered attachment is only because he has suffered a decree, and that he has to satisfy the money claim that is made there. If the money claim is settled, the court will immediately withdraw and proclaim the release of property at release of attachment in the same manner as the proclamation of attachment was done, but at the cost of the judgment debtor. So, always the court cannot do it because it has to get the funds. The funds should always go from either the decree holder Where the decree holder spends, it will be recovered from the sale that is affected as amounts due. But in all these cases where rise and attachment is ordered, the court will ask the judgment debtor to pay the fees for proclamation of the withdrawal of attachment. Withdrawal of attachment under there is a very simple term. Attachment is already there. The court says that I am removing the attachment because the decree is satisfied. Okay. The next is 56. Order for payment of coin or currency note to party entitled under the decree. Who will be entitled to the decree? Either the decree holder or the judgment debtor. If the decree is satisfied, the coins and currency notes that is available in the court will be given to the judgment debtor. Where the decree is not satisfied, it should go to the naturally to the decree holder. Okay. 57 is determination of attachment. What is determination of attachment? Normally, only if there is going to be a counterclaim, it requires an adjudication for determine as to whether the attachment should continue or not. Therefore, the court should see whether the property the attachment should be continued or the execution petition should be dismissed. Therefore, the court will accordingly pass an order saying that the attachment is continued. Why this is said? Because previously we have seen that the decree holder, on passing an order of attachment, should file an application for sale within 6 months. Where the decree holder fails to file such an application within 6 months from the date of an order of attachment, the court will take the determination of attachment and will raise the order of attachment. So, I think it is very clear that there should be no doubt on this. Okay. Then it is 58. Adjudication of claim or objection to attachment of property. See, a property is attached. A third party or some person having an interest in the property comes before court and says, this property is not available for attachment of court by court because this does not relate to the judgment debtor or belong to him. If a claim of such nature is made, proper documents is filed before court, the court will immediately look into it, give an opportunity to the decree holder to satisfy the court the judgment debtor has a right over the property. If the decree holder satisfies the court that the judgment debtor has a right, it will not raise the order of attachment. Where it is satisfied by the third party that he has an interest over and above what is the right of the judgment debtor, and the judgment debtor's right is inferior, or he has no better right than that of the third party who is filing this application, the court has to raise attachment. Therefore, see the second part 58.2. All questions relating to right, title, or interest in the property and no suit will lie once an adjudication is made in EP. Therefore, what should be done in all these proceedings is that since there is a bar to entertain a fresh suit, the execution court should give sufficient opportunity to the parties to prove that the property is that of the judgment debtor, or the third party should be allowed to prove that he has got a better right, title, or interest over the property that is attached under this decree that is in execution. Okay. Then, where the suit is pending in respect of the same property, means or the court feels that the third person who files a application has to establish his right, which he claims by way of separate suit, the court can reject his claim or objection and say, you will have to establish by way of a suit. Then you will have to get the property. See, it is not remediless for the person if this application is refused, even though it says separate suit is not available. Here, the court itself will give a liberty to the party to file a suit under 58(5), saying that you can file a separate suit. I am giving you a liberty to file a separate suit. You can file this suit. Get your right adjudicated there. Then see where the EP has already been proceeded with, something has happened. The person cannot see if the property is sold and it is confirmed, means he has a right only to get himself compensated. Where it is only in the stage prior to confirming the sale. Confirmation of sale is not merely happens by payment of consideration. Sale certificate should be issued, and after the sale certificate, the court will make the sale absolute. So only after that procedure, the right for the third person will be lost. Therefore, that will happen. Then stay of sale. Stay of sale is where the attachment is already advertised for sale. The court can stay either on the application of the person or on the application of third person. Here, what is meant by the application is the determination of the claim application that is pending under 58. Therefore, the court can grant stay of sale pending the determination of an application under 58, not otherwise. 59 would state only that pending an application under 58, stay of sale can be granted, because normally if stay of sale is not granted, the court can proceed to fix the procedure for sale, all other aspects, till such time this application is decided. 60 to 63 is deleted by 76 amendment. We are not concerned with that. Now 64, power to order property attached to be sold and proceeds to be paid to person entitled to. See, why a property is attached? It is only to sell it and settle the money decree or mortgage decree. Settle the money decree or mortgage decree, abdin nama sonnonale, the entitlement is only for the decree holder till the decree is satisfied. What is remaining after the satisfaction of the decree, it will go to the judgment debtor. That is why the section clearly says it will be given to the person entitled to. Entitled to abdin sollum till the decree is satisfied, it is for the decree holder. Once the decree is satisfied, whatever is the excess, it should be paid to the judgment debtor. 65. Sale to be effected by the person. Normally, it is the court or any other person appointed by the court who has to conduct the sale, because the section specifically states, prohibits giving the right to any private person. Giving right to the private person means there is no prohibition. The court appoints an auctioneer, a receiver, advocate commissioner, or any broker. See, they'll not give it to broker. Today, since the section says it should be done by public auction, today it can be done by giving it to e-auction persons who conduct e-auction, where they will advertise in the internet, they will publish in the newspapers, they will tom-tom the property. Today, we don't see tom-tom everywhere, except in Mufsal, we don't have the habit of doing tom-tom in city, but in all outside city, tom-tom is must. In city, what we will do is we'll advertise in vernacular language as well as in English. It will be published in court notice board and in all conspicuous places inside court, collector office, the property, and in the local government office like VAO office or Tahsildar office, like that. It will be affixed in the conspicuous place where normally notices are affixed and public know that such a notice will be affixed here. In 66, it would state proclamation of sale by public auction. I have already said proclamation for the purpose of attachment. Here the proclamation that is said is for sale. These are two different things at two different stages. Proclamation for attachment is different is because what is done is after attachment, the proclamation is done saying that the property is attached. The judgment debtor is not supposed to transfer or create charge, and any person who is going to get it transferred or create a charge will not get any right, is what will be proclaimed. Here, what will be proclaimed is that there is an order by the court that to satisfy a decree, an execution petition has been laid by so and so. In that execution petition, the court has already attached the property, and now that it is bringing the property for sale. The property is situated in the address with town survey number or RS number, then by door number, then specific boundaries, measurement. It will also state in as is where is condition. The proclamation will state the upset value fixed based on the suggestion by judgment debtor and decree holder as to the value of the property, or when the court has already determined the upset price based on the report of an engineer or somebody whose assistance the court has already taken for getting the value, property value, then the upset value fixed by the court, the EMD to be deposited, the time within which the remaining portion is to be deposited, because under the code, the EMD should be deposit EMD plus 25 and up to 25% should be deposited on the day when the sale is effected. The rest of the 75% is to be deposited within 15 days or such further time the court extends. Normally, such an extension will not be granted except for very genuine reasons. So, the proclamation will state the property, revenue assessment, encumbrance, if any, amount to be recovered, upset price, and everything which the court considers material for the purchaser to know about the property. Because under law, it is always that buyer should be beware in respect of an immobile property. So in court auction also the same principle will apply, and because the purchaser cannot at a later stage come and tell the court, no, this is where and I have not verified anything. I have taken the property in sale. I'm not interested. I'm returning the property. He cannot say. Therefore, the court will give an opportunity to the purchaser to satisfy himself that the property can be validly sold. The judgment debtor has a right, and that the court bringing the property in auction has jurisdiction over the property. because we have already seen that execution will be laid only in the court where the property is situated. So the decree might have been passed by any other court. In such a case, we have also seen that the execution will be laid in the court which passed the decree. They will seek for transmission of the decree to the court where the property is situated. We have also seen on the prior, at that time when we said about transmission, that there are two types of transmission. One is transmission by the court itself to the other executing court. The other is delivery, hand delivery. For hand delivery, the person, decree holder, should make an application to deliver the transmitted order, where the court will say whether it is partly satisfied or fully satisfied. The decree is partly satisfied or fully satisfied. Then alone the other executing court will start entertaining the execution petition and go ahead for executing the decree. Then the court will permit verification of the documents, pleadings, for the purpose of the party to satisfy himself about the proceedings also. Satisfy that it is not a fraudulent proceedings or a proceedings where a later third party, there could be an objection that so and so and so and so has colluded and taken a decree, therefore such a decree could not be executed. Abdini, nobody should take an objection also. That also the purchaser should satisfy himself. Then mode of making proclamation. 67. I have already said proclamation will be published in newspaper. Sale it will also be published in Gazette. Gazette la publish பண்ணனும்னா 15 days gap இருக்கணும் for the sale and for the Gazette publication, because Gazette, government Gazette will not entertain, government press will not entertain unless you give 3 days prior plus 15 days for the sale. Unless otherwise such a time is given, the government Gazette will not entertain the publication that is given by a party or from the court. It will say, you take an extension from them, come back here, we'll do it. Then it will state whether the property is sold in whole or in lots. Lots means division of property, say plots, or that single floor means there are 10 floors, each floor is sold, or there are few flats, each flat is sold individually, or the entire property is sold. Then it would also state that the cost of publication would form part of cost of sale. Then all other information, the court feels that it should be published and known to the public for bringing the property for sale. Then 68 is time for sale. Time for sale is the day and time fixed by the court while ordering proclamation. That should be strictly followed. At no point of time the court will entertain an adjournment, or the person authorized to sell the property will permit an adjournment of sale. And that the judgment debtor should consent that it can take place. It has clearly said that there should be 15 days notice. அதான் நான் சொன்னேன் இல்லையா உங்களுக்கு, or at least 7 days for movable property. Movable property ஏன் இங்க கொண்டு வரானா, the procedure for movable property and immovable property is one and the same. The thing is that in movable property, the delivery will be by handing over the movables. In immovable property, the delivery will be by way of bailiff coming to the property, handing over the possession to the person who is the purchaser. 69 is adjournment or stoppage of sale. So the court as well as the officer, though is empowered to adjourn, but only with the leave of the court which has ordered sale, such an adjournment can be granted. Where it is adjourned by more than 30 days, a fresh proclamation is required. Or such a proclamation should be waived by the judgment debtor. So, two conditions if the sale is adjourned for more than 30 days. One is a proclamation should be effected, or if the judgment debtor believes that such a proclamation need not be effected, I have notice. Because who is affected by the sale is only the judgment debtor. His property is brought for sale. Therefore, he has to consent by saying that I don't require the proclamation to be effected. I consent that the court can proceed with the sale, even though it is adjourned after 30 days. '71 will go because, see, we have already seen that the practice of how the deposit has to be made. Again, we will see it little later. Therefore, the provision, last provision in 69 will be a repetition. So, we will take 69.3 with what should be done with by the amount. How the amount should be given in the court, deposited in the court. Like at that time, we will see how this is to be done. That will come in 84 to 86, 84, 85, it will come. Order 21, Rule 84, 85, the provision for depositing the amounts into court, how it has to be done will be defined in the Code of Civil Procedure. Now, 71 is where a purchaser does not pay the EMD, fails to pay the 25, the EMD will be just 5% of the sale price. The remaining 20% should be deposited on the same day when the sale is knocked off. Knocked off na namakku ellarkum theriyum. Say auction takes place. 3 of you participate in auction. Say Dinakar, Shruti and Vaishali takes place. Participate. Shruti is declared a successful bidder. Shruti would have already deposited 5% EMD. On the same day, you should deposit 20% balance. If that failure has happened on the day, or she fails to deposit the balance 75% within 15 days, then she is a defaulter. The defaulting party should bear the cost of publication as well as the loss that is occasioned due to the re-auctioning of property. How a loss can arise? One, the cost of publication, the manner in which it is advertised, then the officer cost for the payment of officer who is conducting the auction, then where the property does not fetch the price for which the purchaser has taken, then the differential price also the purchaser has to pay. This is what is stated in 71. Decree, see, 72 and 73, why it is given so is that a decree holder not to bid or buy property without permission. 72A is mortgagee not to bid at sale without leave of court. What is the distinction? Who is the person who is going to be the decree holder? The mortgagee definitely is going to be the decree holder in a proper mortgage property. in a foreclosure suit. What is foreclosure suit? A mortgage is affected in name of a bank or an institution or a lender. That mortgage is invoked and the person files a suit invoking Order 34 of Civil Procedure Code, saying that the mortgagor has failed to clear his debt. He is due for interest as well as principal. He is not coming forward to pay the amounts. Kindly sell the property and pay the amounts to me in respect of the morals. This is foreclosure suit. Two things. 72 speaks about money decree. One should have clarity. 72 speaks about money decree. 72A speaks about mortgage decree. Therefore, it is very, very clear. Simply as said, he could have said both in one provision, but it may cause little of confusion because a decree holder may be same person, mortgagor might be same person in some suit, or the mortgagee might be different person, the decree holder might be a different person. This can happen is because, see, I mortgage the property at State Bank of India. State Bank of India has assigned the mortgage. I said that asset restructuring company can proceed, get a decree and sell the property. Here, the mortgage is different. The person who is going to get a decree is different. This is one small instance. Assignment of decree will also be there. Assignment of decree will be there. Assignment of mortgage will be there. Assignment of mortgage means the person who is an assignee will be the mortgagee there. But where an assignment of decree takes place, he will not be the mortgagee. He will be just a decree holder. So 72 would state who is a decree holder should not participate and buy the property without permission from court. So formal application for permission should be filed by the decree holder to say that I'll participate in the auction and I'll try to buy the property. Why this is required is that on a later day, this itself will be ground for the judgment debtor to set aside the sale. Therefore, the code as well as the court will clearly see whether the decree holder has sought a permission to participate and buy. Otherwise, it will say you cannot participate and buy. Only with the leave of the court, the decree holder can participate. 72. 72A, it would state the mortgagee should not participate. Without leave of court. Next portion in 72 is where the decree holder participates. The consideration can be set off towards the amount payable to the decree holder. நம்ம set off பார்த்திருக்கோம் already. Set off the amount is due and payable. It is now decreed. It is a determined debt now. The decree is a determined debt. Therefore, the court will state that the amounts that is payable to the decree holder will be adjusted towards the sale consideration. So only if there is any balance to be paid, the decree holder will pay. Otherwise, the court will state that the property is valued this. The decree holder is entitled to the same amount. Therefore, the amount is adjusted. The decree holder need not pay any amount. the property is given to the decree holder. The sale certificate will be issued to the decree holder. The formality of depositing AMD 25%, 75%, all those will not arise in this case. So 72A 2A patalna, it would state the code should state that the reserve price is equal to the principal, interest and cost for sale of immobile property. Where the sale is by lot, it will fix the proportionate rate of principal, interest and the cost of sale. (73) is very, very important, is because the officer who is involved in selling the property should not bid or purchase the property. Why this is brought is because, see, he knows what is the property bought, the worth of the property, what is the decree, everything. The court wanted to be transparent as well as wanted to be fair. When it is to be knocked off by the officer, the fairness of selling will be lost. Adunala the code itself has prohibited the officer from bidding, purchasing the property that is sold in auction. 74 is sale of agricultural produce. 74 and 75 should be read together. Where the agricultural property is brought for sale, it is a growing crop. Growing crop already grown. And the sale will be fixed on the day when it will be ready, where it will be cut and stored in the storage area. And agriculture land, there will be one portion of the land that is kept apart, which will be used to என்ன சொல்றது, அந்த அந்த நெல்லை தனியா எடுக்கிறதுக்கு அதை அடிப்பா, அப்புறம் காய வைப்பா, இந்த ஹேஸ் எல்லாம் காய வச்சு எல்லாம் பண்ணுவோம். அதுக்குன்னு ஒரு தனி பிளேஸ் வச்சிருப்பா. அந்த இடத்துல ஸ்டோர் பண்ணிருக்கிறதுக்கு ரெடியா இருக்கணும். அது அப்படின்னாதான் இட் வில் பி brought ஃபார் ஆக்ஷன். இதுல அந்த சேல் வில் பி போஸ்ட்போன்டு till the இப்போ போஸ்ட்போன்மெண்ட் எப்போ வரும் அப்படின்னாக்கா, இந்த மாதிரி அக்ரிகல்ச்சர் ப்ராடியூஸ்ல தி நெக்ஸ்ட் மார்க்கெட் டே வரைக்கும் வேணா போஸ்ட்போன் பண்ணலாம், அவ்வளவுதான். தட் இஸ் வாட் இஸ் செட் இன் 74(2)B. Okay. Then a fair price is not offered. On 2 grounds, the sale can be postponed. Idhila 75 speaks about 2 things. One is which can be stored. Which can be stored, it can be stored, it can be sold at any time. Where it cannot be sold, it should be sold then and there when it is available for being taken away from the land. And a permission will also be given by the court to enter into the land, cut the produce and take it out. 76 is negotiable instruments and share in corporation. Negotiable and instruments and shares, we have already seen this in the sections. இதுல என்ன சொல்ல வரா அப்படின்னாக்க, அந்த நெகோஷியபிள் இன்ஸ்ட்ருமெண்ட்ஸையும் ஷேர்ஸையும் எப்படி சேல் பண்றதுன்றது. The negotiable instruments, shares வரும்போது court normally it will sell through the brokers or bankers. Ava மூலியமா it will be auction. That is what is being said here. Then 77 is sale by public auction of movable property. So adula vandu what will be said is, again it is same procedure as that of an immovable property, where the court will go for proclamation of sale. It will fix the fair price. It will say the date on which it will be sold. It would be here. It will be only affixed and it will be said about this. Here it will not be by way of a gazette publication. The property sold, movable property sale, there will be no gazette publication. Then the money should be obtained. It should be, receipt should be given. அப்புறம் வந்து the delivery of the property. 78 says that irregularity not to vitiate sale, but any person injured may sue. நான் சொன்னேன் இல்லையா, இப்போ irregularities at the stage, initial stage itself, should be objected to by the judgment or by the person who is entitled to take objections with regard to such irregularities. So after sale, it is not open for a person to say that the irregularity has happened, you set aside the sale. The only remedy available is to file a suit for compensation. Sir, the sale is effected through court auction, then how is entitled to compensation? Wrongfully selling some other third party's property. So the court will normally see that the property of the judgment debtor is sold. Say, நான் இப்போ சொன்னேன் இல்லையா, 58 determination of claim வரும். அவளை வந்து the court would have said that you establish title, come before the court and claim, make a claim சொல்லுவா அப்படின்னு சொல்லிட்டு 58 ஃபைல. In all these cases, the remedy for the person is only to file a suit for compensation. No, and he cannot say, I am entitled to property, you should only give me the property, set aside the sale. 79 is that delivery of movable property. Delivery of movable property, we all know it is by actual seizure and delivering it to the purchaser. இப்போ வந்து அந்த negotiable instrument shares இருக்கு இல்லையா, அதுக்கெல்லாம் என்ன பண்ணிடுவாங்கன்னா, court will pass an order that the creditor should not pay the debt and the company should not transfer the shares till such a time it is transferred in the name of the decree holder. And the ET is transfer of negotiable instruments and shares. It will be assigned. The negotiable instruments shares will be, negotiable instruments will be assigned to the decree holder. Shares will be transferred in the name of the decree holder. இவ்வளவுதான் அதுல simple procedure. Vesting order in case of other properties. Vesting order na the right to take possession. The right to take possession will be given to the purchaser who bids the property. Or the court will state, whoever is in possession of this property which is sold by court auction shall deliver it to the purchaser. That would be the order under 81. 82 again. What court may order sales அப்படின்னு சொல்றான் அப்படின்னாக்க, there is a prohibition that court of small causes alone cannot pass an order of sale, because it is not a civil court. It is just a persona designata. So it is having the power to execute the decree. It is a persona designata and not a civil court. அதனால என்னன்னாக்க, the sale of immovable property cannot be done by a court of small causes. Only for that purpose 82 is said, is very relevant. We have already seen that the court in which the execution is filed or the court which it is transferred is entitled to bring the property for sale. 83 is postponement of sale to enable judgment debtor to raise amount of decree. This can be done where the judgment debtor comes to the court, shows to the court that he has other property which he can mortgage, sell, raise the amount, deposit it into the court. The court is satisfied that the judgment debtor makes a genuine claim before it and say, I will satisfy this decree by selling this property, mortgaging it, or raising the amount on the based on such a property. The court will genuinely postpone the sale. Where the court does not see that the judgment debtor is genuine, the court will not postpone the sale. It will merely dismiss. அதுல ஒரு ஸ்பெசிபிக் ஏதோ சொல்லியிருக்கான். 83 ப்ரொவிசோல செகண்ட் ப்ரொவிசோல பார்த்தேன்னா, no mortgage, lease or sale under this rule shall become absolute until it is confirmed by the court. Until it is confirmed by the court. See, when the court says that so and so is the successful bidder, that is not confirmation again. That is why again and again he is saying until it is confirmed by the court, entire amount is paid and the sale is said it is complete. And the sale certificate issue பண்ணி EP வந்து sale made absolute னு ஒரு ஆர்டர் எழுதணும். அது வரைக்கும் the sale is not complete. The judgment debtor will have his right of redemption. Where the sale deed is, the sale certificate is registered, he will lose his right. From there till the decree is and the sale certificate and the sale made absolute போடுறா இல்லையா, அந்த ஆர்டரோட முடிஞ்சு போச்சு the right of the judgment debtor to redeem the property. He is not entitled to redemption thereafter. Redemption என்ன? Since we have not seen about redemption prior, now 34 order 34 வரும்போது we'll see the redemption of property. Redemption என்னன்னா, the mortgagor, mortgagee யாரு பார்த்தோம், the person who gives loan is the mortgagee. mortgagorங்கிறவர் யாருன்னாக்க, the person who gives the property in mortgage to take a loan is mortgagor. The mortgagor is entitled for redemption. அவர் போய் அவருடைய காசை கட்டி அந்த ப்ராப்பர்ட்டியை திருப்பி வாங்கிக்கிறதுக்கு பேர் தான் redemption. இந்த ப்ராப்பர்ட்டியை சேலுக்கு கொண்டு வர்றது தான் foreclosure. So there are two terms that is used in a mortgage. The right of the mortgagor is redemption, to get his property back by paying the amounts. The right of the mortgagee to bring the property is called foreclosure. These two things we should not forget. Next is '84. Deposit by purchaser and on default for resale. நான் உங்கள்கிட்ட சொன்னேன் இல்லையா, see, the purchaser who bids for the purchase of property, he would have given EMD. On the same day, the remaining 20% he has to deposit. So 25% should have been deposited on the date of sale. Within 15 days therefrom, the remaining should be deposited with the court or the officer who sells the property, or who the court has authorized to receive the money and issue a receipt for the sale of property. So if the purchaser fails to pay the amounts, 25%, then the sale will be cancelled and it will be put for resale. It also states that where the decree holder is the purchaser, the question of deposit does not arise and the requirement can be dispensed with. Time for payment, நான் சொன்ன மாதிரி 85ல it would state that 15 days குள்ள The remaining 75% should be deposited. So, what is a set off? Set off when they say EMD na extra where the amounts for publication, cost of sale, extra deposit panni. The purchaser can ask the court to set off those amounts that is lying into the court towards the consideration for sale of the property to him. 86 is procedure and default of payment. After defraying the sale expenses, the court will forfeit the amount and the property will be resold. Actually, the forfeit amount will not go to the court, it will go to the government. Because the court running is done by the government. It pays the salary to the judges, it pays the court staff, it maintains the court building, it creates, government creates infrastructure. The amount that is forfeited will go to the government, the property will be put for resale. The purchaser will not be entitled to the amounts he has deposited into the court. '87 is notification for resale. The same manner where the sale is effected, resale, same procedure has to be followed. Fresh proclamation will be given. The period will be mentioned. The court may either go with the same price or it may fix fresh upset price depending upon the increase in the value of the property due to the lapse of time. 88 என்னன்னா bid of co-sharer to have preference. Preemptory right தரா. Preemptory right என்ன co-sharer இருக்கா. Co-sharer இருக்கும்போது they should be given the right to bid and take the property first. ஏன்னா third party அந்த ஷேரை purchase பண்ணா the property could not be enjoyed by the co-sharer in the better manner. Third person எந்த அளவுக்கு compatible இருப்பாங்கிறது தெரியாதுங்கிறதுனால this preemptory right is given to the co-sharer. This preemptory right should be exercised before the sale is effected. ஏன்னா நம்ம டிரான்ஸ்ஃபர் ஆஃப் ப்ராப்பர்ட்டி ஆக்ட்ல ஒரு பிரியம்ஷன் பார்ப்போம். அப்படின்னாக்க அதுல இந்த பிரியம்ட்ரி ரைட் எப்போ வரும் அப்படின்னாக்க சேல் எஃபெக்ட் பண்ண அப்புறம் தான் கோஷேரர் சூட் போடணும். எனக்கு அவன் he did not offer the property for sale. He has sold the property, set aside the sale. I will pay the market value. Ask him to execute the sale. '89 is application to set aside sale and deposit. இது எப்போ வரும்? Where the judgment debtor deposits the amounts into the court before the sale certificate is issued and the sale is confirmed, is made absolute. Therefore, இது பண்ணலாம். அதே மாதிரி he should pay a sum of 5% equal to the purchase money for payment to the purchaser. ஏன்னா purchaser he would have spent for registration, for verifying the documents, all those things. Therefore, a 5% should be deposited extra for the purchaser. Decree holder ke enna recovery ki enna amount that should be paid. Or he withdraws the application அப்படின்னா the court can do it. Cost, interest எல்லாத்தையும் சேர்த்து deposit பண்ணாதான் this is possible. 90 application to set aside sale on ground of irregularity or fraud. நம்ம ஆல்ரெடி ஒரு இடத்துல பார்த்துட்டோம். irregularity not to vitiate sale எங்க 78ல. அப்ப 90ல எப்படி சார் irregularity and fraud arises அப்படின்னு வருது அப்படின்னா irregularity or fraud in publishing or conducting it. say இப்போ வந்து proclamation not properly done, say official gazetteல கொடுக்கல, பேப்பர் பப்ளிகேஷன்ல தரல, அந்த ப்ராப்பர்ட்டியில போய் அஃபிக்சர் பண்ணல, இது மூணு ரொம்ப கம்பல்சரி. பாக்கி கலெக்டர் ஆபீஸ்ல ஒட்டல, தாசில்தார் ஆபீஸ்ல ஒட்டல, இதுக்கெல்லாம் யூ கேனாட் ஆஸ்க் ஃபார் irregularity. வேர் இம்மூவபிள் ப்ராப்பர்ட்டிக்கு அபிஷியல் கெசட்ல பப்ளிஷ் பண்ணல, பேப்பர் பப்ளிகேஷன் வெர்னாகுலர் லாங்குவேஜ் பப்ளிஷ் பண்ணல, ஆர் no affixure has not taken place in the property அப்படின்னா the court can say it is irregular. or in conducting எப்போ வரும், or in conducting EMD ப்ராப்பரா டெபாசிட் பண்ணல, 25% is not deposited on same day, 75% is not deposited within 15 days, or the extension has not been granted with the leave of the court, or the postponement is not done with the leave of the court. இந்த மாதிரி கிரவுண்ட்ஸ் இருந்தாதான் the application is maintainable and the court will entertain an application under 90. Tool அழகா போட்டா பாருங்க. No sale shall be set aside on ground of irregularity or fraud in publishing or conducting it unless the facts prove the court is satisfied applicant has sustained substantial injury by reason of such irregularity or fraud. Substantial injury எப்போ வரும், collusion, fraud, lesser price. say இப்போ வந்து டிகிரி ஹோல்டர் லீவ் வாங்காம தேர்ட் பார்ட்டி வச்சு அவனே கொல்யூசிவா வாங்கினா, இவாளுக்கு தெரியாம அந்த irregularity, fraud இதெல்லாம் காமிக்கிறது, அந்த மாதிரி ஈவென்ட் ஒட்டிதான் the court will entertain அழகா சொல்லிட்டான். ஏன்னா ஆல்ரெடி 78ல irregularity is not will not vitiate sale னு சொல்லியாச்சு. Therefore 90 also confirms. Mere absence of or defect in attachment of property sold shall not by itself ground for setting aside sale. This is one more. என்ன அட்டாச்மெண்ட் ஆல்ரெடி எஃபெக்ட் ஆயிருக்கு இல்லையா, அது irregular அப்படின்னு சொல்லி யூ cannot seek setting aside of sale. ஏன் இதை லாஸ்டா கொண்டு வந்து போட்டோம் அப்படின்னாக்க, இது வரைக்கும் சேல்ல இருக்கிற irregularity fraud சொன்னோம். முன்னாடி இருக்கிற அட்டாச்மெண்ட்ல there is an irregularity வந்து இப்ப சொல்ற முடியாது அப்படிங்கிறது தான் இந்த பர்டிகுலர் ப்ரொவிஷனோட impact. 91 is application by purchaser to set aside sale on the ground judgment debtor has no saleable interest. இது எப்போ பண்ண முடியும் அப்படின்னாக்கா, only if the execution petition is pending. அப்படின்னாதான் இந்த provision will apply. During the execution of the decree, the purchaser comes to know that the judgment debtor has no saleable interest. நான் ஆல்ரெடியே உங்களுக்கு சொன்னேன், the purchaser should satisfy about the existence of right on the property as well as that the litigation is properly done. முன்னாடியே satisfy பண்ணிக்கணும்னு ஒரு வாட்டி சொல்லியிருக்கேன் உங்களுக்கு. இந்த சேல்ல proclamation of sale வரும்போது 92 sale when become absolute or to be set aside. இப்போ வந்து சேல் எப்போ வரும், எல்லா அமௌண்ட்டையும் கட்டியாச்சு, சேல் சர்டிபிகேட் இஷ்யூ பண்ணியாச்சு அப்படின்னா அப்ப வந்து the court will make the sale absolute. Then இப்போ வந்து where there is an objection to the sale, நான் சொன்னேன் இல்லையா, right of judgment debtor இல்ல, or the judgment debtor is ready to pay the amounts plus 5% to the purchaser, all those amounts. இல்லைன்னா irregularity in sale, fraud on sale, இந்த மாதிரி இருந்தாலே ஒழிய 92 ஆர்டர் பாஸ் பண்ணியாச்சுன்னா முடிச்சு போச்சு. The sale is complete. 92ல கோர்ட் ஆர்டர் பாஸ் பண்ணிட்டா the sale is complete. அதனால up to 92 the sale is not absolute. Very simple. Up to 92 the sale is not absolute. Once an order is passed under 92 the sale is absolute. From here onwards nobody can ask for the court to set aside the sale for whatever grounds. $93 என்னன்னாக்க where the sale is set aside na the purchaser வந்து should not be affected ங்கிறதுனால the court should order refund of the entire amount that he has paid into court with or without interest. So a discretion is given to the court. With or without interest, na the interest should be recovered only from the judgment debtor, not from any other person or the person because of whom the sale has become liable to be set aside. அப்படின்னா where the irregularity or fraud is due to the decree holder and the sale is set aside, he will be liable to pay the interest if and cost if any ordered by the court. 94 is certificate to the purchaser. This is sale certificate that is issued. Sale certificate normally the court will state that the property was brought on auction on such and such day. The so and so was declared successful bidder. The suit is laid for recovery of so and so principal plus interest. The purchaser has paid the amount of so and so that is fixed by the court as per the orders in execution in EP number so and so. Therefore, a sale certificate is issued in respect of the property mentioned in the schedule here, and the entire property schedule will be given. This is sale certificate. This will be issued in the hands of a judge and signed by the Sharasdar or the registrar. Sharasdar in Mussel Court, registrar in City Court. 95 is delivery in occupancy of judgment debtor. Delivery in occupancy of judgment debtor na nera poite will ask the judgment debtor to deliver the property. The bailiff will go ask the judgment debtor to deliver the property, take possession, give it to the decree holder. 96 is same, where if it is in occupation of tenant, the tenant will be informed that there is a decree and the court has ordered the delivery of possession. Therefore, he is obliged to deliver possession. Some reasonable time will be given to the tenant to vacate. Then the delivery will be effective. 97 is resistance and objection. Resistance and objection. This is the last provision available to see that the property's possession is not taken by the purchaser after purchase. இது ஏன் இந்த மாதிரி சொல்றோம் அப்படின்னாக்க, resistance or objection can only be by a judgment debtor or a person in possession of the property. Person judgment debtor என்னென்ன resistance கொடுக்க முடியும்? The property is not the property that is sold. The property is not properly identified. The boundaries that is defined in the property is wrong. The extent that is divided the sale deed is wrong. Unless otherwise the property is identified, I will not deliver the property. Or a third person saying that the judgment debtor does not have a right, or I have a right by adverse possession. I have been in possession for quite a long time. Therefore, I have a better right now. Then the person or the judgment debtor should come before the court, file an abstract or petition or a resistance application under 97. After notice to the judgment debtor to the decree holder, the court will conduct an inquiry as to whether the obstruction or resistance is valid. If there is no valid obstruction or resistance, the court will order removal of obstruction or resistance. It will direct delivery. That is said in 98. '99 is where the purchaser is dispossessed because of the obstruction or resistance of the he can apply to the court seeking for possession. That is 99. The court will determine whether it has to allow or dismiss the application is because, see, this is only after delivery, not prior to delivery. இதுல ஒரு விஷயம் இருக்கு என்னன்னாக்க the person who has to apply to the executing for delivery should make an application within 1 year from the date of purchase to the executing court seeking for delivery of possession. Purchaser பொறுத்த வரைக்கும். If he does not make an application within 1 year, he has to only file a regular suit for possession. Okay, very clear, no? If a person who is a purchaser does not file an application to hand over possession within 1 year, then he should file only a regular suit for possession. 101 எப்படின்னா all the applications in the abstract or applications, then the delivery of possession, then and the resistance to delivery, ellame should be adjudicated upon, and the question should be framed to be determined by the court, and the court should determine it there itself, because it is an appealable decree. 103 la பார்த்தல்ல, it is an appealable, it should be treated as decree and appeal will lie. அதனால இது இந்த provision is not applicable. எது 98 abstract and the order of adjudication, possession, delivery of possession, இதெல்லாம் வந்து is not applicable to transferee pendentility. ஏன் அப்படின்னா, see, pendency late transferee na yaare person who has purchased the property pending litigation, knowing that if a decree is passed, he will not get any right. Anga poi na bona fide purchaser for value, you cannot take a plea. The only criteria that is defined here is pendentility purchaser. Okay. Therefore, the pendentility purchaser 98 to 100 is not applicable. அப்படின்னா the adjudication process that is defined for a third party is not available to transferee pendentility. That's simple. So order is appealable நம்ம சொல்லிட்டோம். Then 101 to 103 to be subject to result of pending suit. Pending suit na என்ன? I already told you. இப்போ வந்து 58 ஃபைல கோர்ட் வந்து நீ போய் you establish your right, come back, then alone you are entitled to it ன்னு சொல்லுவான்னு சொன்ன இல்லையா, அந்த மாதிரி இதெல்லாம் வந்து இந்த இடத்துல வந்து வந்துரும். அந்த 104ல வந்து any pending suit where the same similar right in respect of this property is determined அப்படின்னா இந்த order under 101 to 103 will be subject to the result of that suit. 105 hearing of application. Hearing of application na inna nama முன்னாடியே பார்த்திருக்கோம் trial of suit, hearing of application, how it is to be done. After notice to parties, the party should be given proper hearing. The court should fix date of hearing. Any evidence, if any, to be let in by the parties, the court should permit in all this, in the abstract determination of right as to the title at this stage also. The court has said there cannot be any one more suit in respect of the rights determined in this execution. The court should follow the procedures very strictly and say that the entire process, the equal opportunities given to all parties to prove their claim or to defend the claim. 106 is setting aside ex parte order in execution. In the 106 is a very controversial provision, is because see நிறைய judgments இருக்கு இன்னைக்கு. எப்படின்னாக்க இந்த 30 daysக்குள்ள ex parte decree petition போட்டுருந்தோம், இந்த ex parte order petition போட்டுருந்தோம். எக்ஸிக்யூட்டிங் கோர்ட்டுக்கு கண்டோன் டிலே ப்ரொவிஷன் கிடையாது அப்படின்னு ஒரு பெரிய கான்ட்ரவர்சி இருக்குது. நம்ம ஜட்ஜ்மெண்ட்ஸை ஒரு நாள் தனியா பார்க்கலாம்னு சொன்னதுனால இப்போ நம்ம அந்த இதெல்லாம் பார்க்க மாட்டோம். 106 will only speak about the power of the court to set aside ex parte order where a party could not appear. He set ex parte in the proceedings. He can come and file an application explaining the court that he has reason for him to that he could not appear before the court prior, and to set aside the ex parte order that is passed in execution. And idhula rendu condition kuduthirukkan. Notice should be served to the other party. Other party na definitely decree holder, and 30 days has expired. So 30 days kulla போடணும். இதுல போட்டுருக்காங்க பார்த்தீங்களா, 30 days has expired இல்ல, 30 days from the date of order or knowledge of the order. So 30 days from the date of order or knowledge of the order. Knowledge of the order, you should prove when you got knowledge. So only when there is a strict proof of your knowledge that I come to know about the ex parte order on such and such day, the court can say that yes, he has knowledge. Otherwise, the court will take your date of knowledge as the date on which the order of ex parte is passed. So with this, we conclude order 21. Execution is over. Execution is over அப்படின்னு சொல்லும் போதே இதுல எப்படின்னா, the entire process of execution is very well defined in civil procedure code, except on the procedures defined under the civil procedure code. The court cannot sell or entertain any other application. இதுல எப்படின்னா, ஒரு இன்னும் கொஞ்சம் ப்ரொசீஜர்ஸ் வேணா ஃபாலோ பண்ணலாம். இந்த இன்கம் டேக்ஸ் ஆக்ட்லாம் சில ப்ரொசீஜர்ஸ் இருக்கும் ரிகார்டிங் சேல். அந்த மாதிரி ஏதாவது அடிஷனல் ப்ரொசீஜர் ஃபார் ப்ரிசர்வேஷன் ஆஃப் ரைட் ஆர் இந்த ஃப்ராடு இதெல்லாம் இர்ரெகுலரிட்டி எல்லாம் இல்லாம இருக்கிறதுக்கு ஏதாவது ப்ரொசீஜர் இருந்தா ஃபாலோ பண்ணலாம். பட் ஃபாலோயிங் ஆஃப் தி procedure that is prescribed under the code is mandatory in execution under order 21. Normally 21 applies to the execution proceedings even before small cause court. With this, we will conclude today's session. Any question you can